In order.
Yep. I'd like to call this meeting in order.
Okay, roll call is Jacob Beach,
Here in Kalamazoo.
Janine Brown, Gabriela Dela Cruz,
Present in Kalamazoo.
Jessica Glenn,
Here in the city of Kalamazoo.
Angela Graham Williams, Marissa Harrington,
Here and present in Kalamazoo.
and Deshaun Houston.
Here in Kalamazoo.
Okay, and we also have staff, Attorney Clyde Robertson, Tanessa Patterson, and Dorla Bonner, and Vice Mayor Griffith is joining us even as we speak. I would also like to give you our welcome, if you don't mind, Chair. I can do that. Welcome to the April 7th, 2021. Woo, I went back. Civil Rights Board meeting. Just a reminder for public comment, please call 269-226-6573. And that number is also on your screen, 269-226-6573, and leave a voice message limited to 3 minutes. During citizens' comments, your voicemail messages will be played back for the good of the order. Closed caption is available via the City of Kalamazoo Facebook live stream and will also be available on the YouTube replay. Thank you, and back in your hands, Mr. Houston.
All right. Thank you so much, Director Bonner. I'd like to ask a motion to excuse Director Graham Williams, excuse me.
I move to excuse Director Graham Williams from today's meeting.
Moved by Director De La Cruz. One.
Second by Director Brown.
And second by Director Brown. All right, motion is accepted. And hi, Director Brown, how's it going?
Going good, having some technical issues, but here
All right, good.
and in Kalamazoo.
Thank you, ma'am. All righty. I'd like to ask, we'll move on to the next item, the adoption of minutes. Would we like to change any of the agenda?
May I just add before this, just a reminder that this is our opportunity at the beginning of the meeting to change the agenda. So if you notice anything like should be different, make sure to bring it up at this point. I'm usually the one putting together the agenda. So just let me know beforehand, but then you also have an opportunity here just as a reminder. So continue, sorry.
Oh, you're good, thank you. Go ahead.
If we could add the education subcommittee met, and if we would like to provide an update to the board as a whole.
Sorry, I'm writing that down. And sorry, for some reason, I think it's my speakers a little low. So if I'm going like this is because I can't hear, so forgive me. Anyone else would like to add anything or make any changes? Okay. And Attorney Robinson, I have to ask, in order for the changes to be made, do I have to make a motion to accept the changes in addition to accepting the agenda? You're muted.
I believe I can motion to accept the agenda with the recommended changes.
I'd like to move. Oh, go ahead.
I was just going to say this is Director Harrington, and I second that motion.
All right, Director Reach first, Director Harrington second. Agenda accepted. I'd like to also know if there are any changes to any of the minutes. No. All right, Chair, I'd like to ask for a motion to accept the minutes for last week's last meeting. Wow, excuse me.
I motion that we accept the minutes.
Director Beach first.
I second Janine Brown.
Director Brown second. Minutes accepted.
Oh, you have to
Are-
vote. You have to vote to approve the minutes.
All in favor, say aye.
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 Director Brown.
Any that do not agree? All right, we move to accept the minutes. Are there any public comments and communications from any staff?
I do have some communications. First is that on next Tuesday, the 13th, the Citizens Public Safety and Review Appeal Board, CSREP, will be having a public hearing on a complaint. And I thought it would be good for all of us, if it's in any way possible, we can watch it and see what it looks like live. This will be the first one I've seen since I've been a part of this process. So next Tuesday night at 6 o'clock, if we want to see what it's like, you know, one of the things we talked about earlier was about a person's personal information and all of that being exposed. Well, this is our time to see how it's done. So I would like to invite you to attend that meeting. Also, I know I've talked about it before, but the city is undergoing a diversity, equity, inclusion assessment, an internal assessment. Part of that assessment is also a survey to kind of gauge the temperature in this area. We are also surveying boards and commissions. So the latter part of this month, you will get, this month, early May, somewhere around there, you will get an assessment. It'll come from me, but the link will not, it will just have a link, and then I will no longer be a part of it. So I won't see who said what. It goes directly to the organization, the Michigan Public Health Institute in Lansing. But the link will come from me. So I just really encourage all of you to participate. We need as greater participation from staff and boards and commission as possible. This will give us the information to develop our first diversity, equity, inclusion plan for our city. So that's exciting. That's exciting. And those are my announcement. Attorney Robinson, if you have anything.
No, I do not.
Okay, thank you. So we are done. Thank you, Chair Houston.
Director Bonner, could you please send out that where we could, the information for the complaint in email to us all?
Yes, if you have liked the city's page, you will get an alert.
Thank you.
You get one for every meeting we have at the city.
I get them, so right up there. Thank you.
Okay, but I'll send a reminder. But just so you know, the link will be in the alert.
Perfect. Thank you, Director Bonner.
Yeah.
All righty. Old business. So it looks like we're going to continue to review the ordinance, or excuse me, new business. My apologies. Review the ordinance, Chapter 18A, Fair Housing. And we're going to finish up here with Article 1, 2, and 3, general provisions for 1, fair housing standards, and 3, enforcements. And I am going to again hand this over to Vice Chair Dela Cruz to continue on what she started.
Thanks, Chair Houston. This will be the last reading of these ordinances. So I'm going to share my screen now. Oh, it says that.
Go ahead.
It says that I don't have screen sharing capabilities this time.
IT, can you fix that for us, please?
Okay, it works now. There it is.
Thank you very much.
And as a reminder, I might not see you raise your hand. So if you have a question, just blurt it out. Or if you want me to stop or reread or anything. Chapter 18A, Fair Housing. Article 1, General Provisions, 18A-1A, or Policy A. It is the policy of the City of Kalamazoo in the exercise of its municipal authority for the protection of the public health, safety, and general welfare that all residents be assured of an equal opportunity to live in adequate housing facilities and prohibit unlawful discriminatory practices in housing and real estate transactions. B, the provisions against discrimination provided for in this chapter do not preempt federal or state law, but are intended to supplement existing state and federal civil rights law to prohibit discrimination and practices in the area of housing not addressed at state or federal law, especially in regards to actions taken because of an individual's source of income, status as a victim of domestic violence, survivor of domestic violence, prior arrests, or conviction record. Provided, however, this chapter shall be construed and applied in a manner consistent with First Amendment jurisprudence regarding the freedom of speech and exercise of religion. So that paragraph just describes the supplemental classes and the reason that we have this ordinance to supplement the federal and state ones. 18A-2, definitions. A, any term used in this chapter shall have the definition as provided in Chapter 18, non-discrimination, which we've reviewed. B, as used in this chapter, the following words and phrases have the following meanings. Actual eviction, the completed legal process of a landlord removing a tenant from a rental property. Adverse action, to evict an individual, fail or refuse to rent or lease real property to an individual, or fail or refuse to continue to rent or lease real property to an individual, or fail or refuse to add a household member to an existing lease, or reduce any tenant subsidy. The adverse action must relate to property located in the city of Kalamazoo. Agent, a person acting on behalf of a housing facility entity. Applicant, an individual applying to rent or lease a housing facility, and an individual applying to be added to an existing housing facility lease. Blanket policy, a policy or practice that generally treats an individual as a member of group based on a particular characteristic as opposed to singularly. Directly related conviction, the conduct for which the person was convicted or that is the subject of an unresolved arrest that has a direct and specific negative bearing on the health, safety, or right to peaceful enjoyment of the premises by persons and includes one or more of the following offenses. 1. Any conviction where state or federal law prohibits the applicant from being eligible for public housing, or any conviction that leads to the applicant becoming a lifetime registered sex offender. I have a question about this. Attorney Robinson, could you give us an example of a conviction where state or federal law prohibits the applicant from being eligible for public housing?
My understanding is there are certain drug offenses that disqualify somebody.
Okay, thank you.
This is Director Beach. I can confirm, yes. Particular drug offenses, some manufacturing drug offenses
Okay,
can remove people from that possibility.
all right, I see. Thank you. Eviction filing, a legal filing intended to start the process in which a landlord removes a tenant from a rental property. Evidence of rehabilitation includes but is not limited to a person's satisfactory compliance with all terms and conditions of parole or probation. However, an inability to pay fines, fees, and restitution due to indigence shall not be considered regarding compliance with terms and conditions of parole or probation or both. Employer recommendations, especially concerning a person's post-conviction employment, educational attainment, or vocational or professional training since a conviction, including training received while incarcerated, completion or active participation in rehabilitative treatment, such as alcohol or drug treatment, letters of recommendation from community organizations, counselors, or case managers, teachers, community leaders, or probation or parole officers who have observed the applicant since their conviction, and the length of time since conviction or release from incarceration. Successful completion of parole, probation, mandatory supervision, or post-release community supervision shall create a presumption of rehabilitation. Housing facility. Any dwelling or facility used or intended to be designed to be used as the home, domicile, or residence of one or more persons, including but not limited to a house, apartment, rooming house, housing cooperative, homeless shelter, hotel, motel, tourist home, retirement home, or nursing home. Landlord, any owner, lessor, sublessor, managing agent or company, or any other person that rents, leases, or approves the rental or lease of a housing facility or makes tenancy decisions. Public housing, rental housing facilities developed with federal, state, or local government, city or county funding, or which pay an annual service charge in lieu of taxes and are intended for eligible low-income individuals and families, the elderly, and persons with disabilities. Real estate transaction, the sale, exchange, rental, or lease of real property. Rental application fee, any fee paid by an applicant to a landlord to permit a background check of the applicant before or after a leasehold contract is created. Source of income, lawful verifiable income derived from wages, salaries, or other compensation for employment. Money derived from a gift or bequest. Contract, including insurance proceeds. Loan, or the settlement or award for a claim for personal injury. It also includes, but is not limited to, Social Security benefits, supplemental security income, unemployment benefits, retirement income, alimony, child support, federal housing choice voucher, local housing assistance fund millage, or any other housing subsidy. Survivor of domestic violence, an individual against whom any of the following acts were perpetrated by a person that was not in an act of self-defense. 1. Causing or attempting to cause physical or mental harm to a family or household member. 2. Placing a family or household member in fear of physical or mental harm. 3. Causing or attempting to cause a family or household member to engage in involuntary sexual activity by force, threat of force, or duress. 4. Engaging in activity toward a family or household member that would cause a reasonable person to feel terrorized, frightened, threatened, harassed, or molested. 5. Conduct constituting sexual assault as described in MCLA 750.520A to 750.520I. 6. Conduct constituting stalking as defined at MCLA 750.411H and 750.411I. Blank page. Article 2, Fair Housing Standards. 18A-3, Discriminatory Housing Practices. Except as otherwise provided in this chapter, A, no person shall discriminate in leasing, selling, or otherwise making available any housing facilities. B, no person shall discriminate in the terms, conditions, maintenance, or repair in providing any housing facility. C, no person shall refuse to lend money for the purchase or repair of any real property or insure any real property solely because of the location in the city of such real property. D, no person shall promote real estate transactions by representing that changes are occurring or will occur in an area with respect to any protected classification. I have a question about C. It says no person shall refuse to lend money for the purchase of repair or real property or insure any real property solely because of the location in the city of such real property. How would somebody prove that the person had denied them for that reason?
Either through direct or indirect test evidence. If an insurance agent outwardly said, we don't write policies for that area of the city.
Mm-hmm.
That would be clear proof that there was a problem. On the other hand, if there is circumstantial evidence that demonstrates the same thing, even though they didn't directly say it, that would also be a matter of proof.
And if they did say it, would that be like enough evidence to move forward? Like if it wasn't recorded or anything like that?
Well, you're going to obviously have that circumstance in terms of what did some person say or not say.
Mm-hmm.
Obviously, a insurance agent would deny it, probably. Yeah. But on the other hand, if you can demonstrate indirectly that insurance company isn't writing insurance policies for that area of the city, that would be proof. Again, this is an attempt to avoid redlining and the like.
Yep. Okay, thank you. E, no person shall place a sign or other display on any real property which indicates that the property is for sale or has been sold when it is not for sale or has not recently been sold. F, landlords must carefully consider the reason for and length of time since an actual eviction of or eviction filing against a rental applicant. No landlord shall have or enforce a blanket policy that prohibits renting to a person based on eviction filings or actual evictions, or outright bans prospective tenants with prior actual convictions or eviction filings. G, no person is permitted to establish a blanket policy banning any aspect of housing because of a conviction record, except when mandated by federal or state law. H, a landlord may not refuse or base an adverse action in whole or in part on either an applicant or tenant with the status as a victim of domestic violence, survivor of domestic violence, or having an early lease termination under MCLA 554.601B. I, no person shall fail to account for any tenant or prospective tenant's entire source of income when using a financial income standard for entering into or renewing a tenancy or lease for a housing facility. J, a landlord may not require an individual who receives housing assistance of dedicated rent via voucher or any other housing subsidies to earn any more than what is needed to pay for utilities as a requirement for tenancy. 18A-4, rental housing, prohibition on criminal record inquiries. A, no person shall use any criminal history information other than convictions contained in a conviction record to deny an individual any aspect of housing. An individual's conviction record may only be used to deny the individual housing if the landlord considers an applicant's conviction record, taking into account such factors as evidence of rehabilitation, the length of time since conviction, the severity of a criminal conviction, the relevance of the conviction to housing, and any circumstances surrounding the conviction relating to disability or domestic violence. This provision shall not bar a landlord from considering criminal conduct occurring on the premises of the landlord's property, regardless of whether that conduct resulted in conviction. B, it is a responsibility of a landlord to ensure that its employees and agents comply with this section. C, regarding applicants and their household members, a landlord may base an adverse action in whole or in part on directly related convictions that have a direct and specific negative bearing on the safety of persons or real property, given the nature of the housing, and includes one or more of the following. 1, any conviction where state or federal law prohibits the applicant from being eligible for public housing, or 2, any conviction that leads to the applicant becoming a lifetime registered sex offender. D, the landlord shall promptly notify the applicant of any final adverse action based upon their conviction history or contents of the criminal background check. E, it shall be unlawful for any landlord to engage in a communication, including the production or dissemination of advertisements related to housing that expresses, directly or indirectly, that any person with an arrest record or conviction record will not be considered for the rental or lease of real property, or may not apply for the rental or lease of real property, except as permitted by local, state, or federal law. For purposes of this subsection, this is in quotes, engage in a communication includes, but is not limited to, making a verbal statement or producing or disseminating any solicitation, advertisement, or signage. F, a landlord shall state in all solicitations or advertisements for the rental or lease of the eligible housing or made on their behalf that a landlord will consider qualified applicants consistent with this chapter. This language shall include, at a minimum, the following statement. The rental or lease of this property must comply with the City of Kalamazoo ordinance regulating the use of criminal background checks as part of the tenant screening process to provide individuals with criminal backgrounds a fair opportunity. For additional information, please contact the City of Kalamazoo Civil Rights Board. 18A-5, rental application fees.
I have a question real quick for Attorney Robinson.
Mhm.
It's just real quick, public housing, and I've seen housing, but is public housing an additional or defined term, or is that just, does that mean housing?
Public housing is defined. It was, I think on the second or third page.
Let's see, I'll go to it. Rental housing facilities developed with federal or local government, city or county funding. And then they pay an annual service charge in lieu of taxes. And they're intended for low-income individuals and families, the elderly, and people with disabilities.
Okay, I missed that. I don't know how I did, and I just wanted to make sure that I understood that correctly to mean exactly that. Thank you so much.
Thanks. Let's see. Oops. Okay. 18A-5 rental application fees. A rental application fee may not exceed the actual cost of the background check process, which may include national, state, and local criminal histories, credit reports, rental history records, reference checks, eviction records, and employment verification obtained by a landlord to screen an applicant. An application fee shall not include administrative fees, except for actual reasonable costs necessarily incurred to check the rental history and employment verification of an applicant. Landlords must provide applicants an itemized explanation of an application fee. Do they need to provide that explanation with every applicant, or just when they're when it's requested?
I'm trying to remember what we, that should be supplied with any application.
Okay.
And I have a question. When you say reasonable, is reasonable meaning that they just pass on, let's say if the credit report costs $40, they just reasonably pass that cost on? There's no additional fee on top of that? Is that what you mean by, is that
Yes.
what it means when you say?
Mm-hmm.
Okay.
Attorney Robinson, this is Director Beach. Could you clarify, because I think it's important, reasonable also does include staff time. Can that also include processing time in terms of like staff time, as long as it is reasonable? Or is it just the hard cost?
Well, again, I'm not familiar with the process since I've not a landlord. So I'm assuming they get a report and they review it. I don't know what more staff time would be engaged in reading a report. It seems to me that unless it's rather voluminous, it shouldn't take more than a few minutes.
Mm-hmm.
Yeah, that is correct.
Okay.
It's not intensive at all.
And the ordinance says that they have to provide an itemized explanation. So that would explain what they're charging for, what they're charging for.
Thanks, everybody.
Thank you.
A landlord must provide an applicant with any reports or correspondence generated as a result of the screening process to the extent permitted or required by state and federal law. B, before receiving a rental application fee, a landlord must provide a written notice to the applicant setting forth the criteria on which the application will be judged and the amount of the application fee that will be charged. The amount received shall not exceed the amount disclosed. So no surprise fees. C, landlords shall only advertise housing facilities, receive applications, screen applicants, and accept rental application fees for properties that are readily available for rent and occupancy, unless an applicant consents in writing to being added to a waiting list. A housing facility is no longer considered readily available if a different applicant has been offered the housing facility and accepted and has placed a deposit on the housing facility. Wow, I didn't know that was the case before. For purposes of this section, a housing facility will be considered readily available if a tenant of the unit has declared they will not be renewing the lease. Landlords shall document the date and time that deposits are placed on housing facilities. D, a landlord may collect and hold an application fee for an available housing facility for up to 30 calendar days, so long as the landlord provides a written receipt to the applicant. If a housing facility becomes no longer available after applications and application fees are received, but before some applications have undergone this screening process, all application fees associated with unscreened applications must be returned to the respective applicants within 14 calendar days from the date the housing facility is no longer available for rent. Hopefully that was understandable. E, in all cases where an applicant is not offered the housing facility applied for, the landlord shall provide the applicant with a written statement explaining the reason or reasons that the housing facility was not offered to the applicant. The explanation must provide the applicant with a clear statement of the reason or reasons that the housing facility was not offered, along with any documentation substantiating the reason or reasons. F, if an applicant believes the application fee exceeds the actual cost of the screening process or believes that the reasons for denial deviate from the disclosed criteria for evaluating the application, or believes that the landlord has violated any other requirement of this section, the applicant or their representative may, within 30 days of receipt of the denial, file a written complaint with the city manager or the city manager's designee. For purposes of this section, a denial means any circumstances which the applicant is not offered the housing facility. G.
This is Director Beach. Attorney Robinson, are landlords able to collect applications and keep the application if they process them, and keep the application on file if they have a large stock of units? So if it's not for that intent, if they put the application on file, do they have to return it, or are they able to do that if they have like a large stock?
Well, this is new language. It was adopted from a Grand Rapids ordinance. And so I'd have to do a little bit of research in making that determination. Generally, if you're not going to rent to somebody, you're going to return that application fee because you haven't really used it. But on the other hand, if the applicant agrees and say, yeah, keep my information on file, and because I may be interested if something comes up, then I think that would be all right.
Director Beach, this is Vice Mayor Griffin, if I'm able to weigh in. And of course, Attorney Robinson, just to get your clarifying, just to make certain, but from what my understanding is exactly what Attorney Robinson lifted up, that as long as
I think you muted yourself, Vice Mayor.
I apologize. I think I got into a difficult space. As long as the understanding is clear with the applicant at the time, and as long as they know their application is going to be on file for another apartment that may become available, and they're clear on that, then they're able to hold their application and their fee for longer. But if that's not the agreement at the onset, then once the unit that they applied for becomes no longer available, then they need to return the fee.
But that has to be established at the onset. That makes sense. Thank you.
Well, I suppose it could also be established if, for instance, you've rented to somebody else, but the individual still is interested in moving into the complex and offers to have their application remain on file for the next open unit. And in that case, my advice would be that the landlord get a written statement and a signature from the applicant saying that, yes, you are permitted to hang on to my application fee and the application pending another unit within a reasonable time, I suppose. You could say for 90 days or even up to 6 months, whatever you agreed to, but get that agreement in writing so there is no question as to whether or not that agreement took place. But as the Vice Mayor explained, that was my understanding of what this provision was attempting to do.
So, I think it's important we get that clarification, especially for our landlords in our community and just for the residents who are applying for applications, because there are a lot of landlords who own multiple single family homes. And so when it's not necessarily a waiting list situation, I think complex is when there's a clear waiting list of the next available unit. But when you get into single family homes, you then fall into how long can you hold it for? What if there's just a lot of factors. If the applicant doesn't want that particular single family home, and it's the next one up. So I just think it's important we get that clarification so we can be able to be clear on what we expect from landlords.
Thanks, everyone. G, if it is determined that a landlord has violated this section, in addition to any fines imposed as a result of municipal civil infraction, the rental property owner must refund the entire application fee to the applicant, including but not limited to situations in which the screening process has not occurred or has not been documented sufficiently prior to denial. 18A-6, exercise of rights protected, retaliation prohibited. A, it shall be unlawful for a landlord or any other person to interfere with, restrain, or deny the exercise of, or the attempt to exercise any right provided under this chapter. B, it shall be unlawful for a landlord to interrupt, terminate, or fail to refuse to initiate or conduct a transaction involving the rental or lease of eligible housing, including falsely representing that such property is not available for rental or lease, or otherwise take adverse action against a person in retaliation for exercising rights protected under this chapter. Such rights include, but are not limited to, 1, the right to file a complaint or inform any person about a landlord's alleged violation of this chapter. 2, the right to inform the administering agency about a landlord's alleged violation of this chapter. 3, the right to cooperate with the administering or enforcing agencies or other persons in the investigation or prosecution of any alleged violation of this chapter. Or 4, the right to inform any person of their rights under this chapter. C, protections of this section shall apply to persons who mistakenly but in good faith allege violations of this chapter. D, taking adverse action against a person within 90 days of the exercise of one or more rights described in this section shall create a rebuttable presumption in the administrating agency's investigation of such adverse action that such adverse action was taken in retaliation for the exercise of those rights.
Question, hold on one moment. So Attorney Robinson, what does interrupt mean?
Interrupt, you mean?
Yep, so it'll be B, it shall be unlawful for a landlord to interrupt, terminate, or fail to refuse to initiate or conduct. What does interrupt mean? Can you go a little bit deeper into that?
That may have been a typographical error now that I'm looking at it.
Okay.
But the other way it could be done is could be maybe and I'm thinking, although it's not defined, there are, for instance, if the landlord shuts off utilities as kind of a constructive way to kind of evict a person. You're not permitted to do that, but if you turn off the heat or don't pay the gas bill because the utilities are being paid by the landlord, that could be a way of interrupting a tenancy.
Okay. And then could you summarize D for us? Or at least for me, I shouldn't say for us. Everyone may understand, but I'm a little confused on D.
If within if an individual has exercised one of their rights, for instance, they've complained about a landlord, although you're still a tenant there, but you've complained about maybe you felt discriminated against because you weren't permitted to bring on another family member to live with you or something, and so you made a complaint. Then the landlord all of a sudden decides to end your tenancy, even though you're paid up. That would be an adverse action, and if it was taken within 90 days of the denial to lease or add somebody to the leasehold, that creates a rebuttable presumption that the termination of the tenancy was taken in retaliation for the making the complaint.
Thank you for that clarification.
And this type of provision is very common in civil rights law. That if an individual merely makes a complaint that their civil rights have been denied, it's not appropriate for an employer or a provider of a public accommodation or education to then take action against that individual. And it's usually, again, a rebuttable presumption that if you do take retaliate, or you do take action against the individual, it's deemed as a retaliation, unless you as the individual who's taking the action can say, no, there's other reasons I did this. For instance, the example that I just gave, if the individual who made the complaint is now 3 months in arrears and the landlord says, I'm going to evict you because your rent's not up to date, while there's a presumption that looks like an adverse action that was taken in reaction to a complaint being filed, the landlord can say, no, I took that action because they're 3 months in arrears. And that would rebut the presumption then.
Okay. Thank you very much for that.
Yeah, thanks for that example. 18A-7, exceptions. The following practices are not violations of this chapter. A, for a religious organization to restrict the occupancy of any of its housing facilities or accommodations which are operated as a direct part of its religious activities to persons who are members of the denomination involved or who agree to conform to the moral tenets of that religious organization. This exception does not include housing facilities or homeless shelters that are generally made available to the public at large as part of the religious organization's mission, proselytizing, or religious activities. B, for the owner of an owner-occupied one-family or two-family dwelling or a housing facility or public accommodation facility, respectively, devoted entirely to the housing and accommodation of individuals of one sex, to restrict occupancy and use based on sex. C, to limit occupancy in a housing project or to provide public accommodations or employment privileges or assistance to persons of low income, persons over 50 years of age, or disabled persons. D, to discriminate in any arrangement for the shared ownership, lease, or residency of a housing facility. E, in the rental of housing facilities in a building which contains dwelling units for not more than two families living independently of each other, if the owner of the building or a member of the owner's family resides in one of the dwelling units, or to the rental of a room or rooms in a single family dwelling by an individual, or if the lesser or a member of the lesser's family resides in the dwelling. 18A-8, landlord records. A, unless prohibited by federal or state law, a landlord shall maintain and retain records of tenant application forms and other pertinent data and records required in this chapter for a minimum of 1 year from the date of application, and shall allow the administering or enforcing agencies to access such records with appropriate notice and at a mutually agreeable time to monitor or verify compliance with the requirements of this chapter. B, at no time shall the administering or enforcing agencies require a landlord to provide any information or documents, the disclosure of which would violate local, state, or federal law. C, anytime a landlord does not maintain or provide adequate records of documenting compliance with this chapter, or does not allow reasonable access to such records, the office of the Chief Financial Officer or other city department or agency shall have the authority to provide all non-financial information necessary to fulfill the administering or enforcing agency's responsibilities under this chapter, subject to applicable federal and state confidentiality laws. Blank page. And then Article 3 is enforcement. 18A-9, notices. The city manager or his or her designee shall publish on the city website and make available to landlords in all languages spoken by more than 5% of the city population a notice suitable for posting that informs housing applicants of their rights under this chapter. This notice shall be updated on or before December 1st of any year in which there is a change in the language spoken by more than 5% of the city population. 18A-10, remedies. The provisions of this chapter are to be enforced through any of the mechanisms provided at Article 3 of Chapter 18. And it says 18-9 through 18-13. 18A-11, commencement of enforcement. No complaints seeking the enforcement of the provisions of this chapter may be filed with the city prior to November 30th, 2020. And it's after that, so we don't have to worry about that. Does anyone have any more questions or comments before I close this? Okay, I'm gonna go ahead and close this. Actually, I have a question. For the notices, it says this notice shall be updated on or before December 1st of any year in which there's a change in the language spoken by more than 5% of the population. How do we keep track of that?
US Census.
Okay. And that's every year?
They don't do it every year, but there's an office of, and I don't have the document in front of me, that they do kind of an idea as to an estimate of where population is moving in the 10 years between census. And they oftentimes reflect if there's a significant ethnic or minority population that is increasing in a particular area. So we would have that information from the federal government or an agency of the federal government between census.
Okay.
Are you referring to the American Community Survey?
Yep, that's it.
That happens every 5 years. The census happens every 10 years.
Mm-hmm. All right, thank you. I'm gonna go ahead and stop sharing.
Thank you, Vice Chair.
Mm-hmm.
Can I make a comment? Just so everyone would know that we are still training landlords. We in being the Fair Housing Center of Southwest Michigan, the Michigan Department of Civil Rights, and the City of Kalamazoo on the federal, state, and local ordinances. The next training is actually next Thursday on the 15th. So the trainings are listed on the city's website with the link to register, or a landlord can call the Fair Housing Center of Southwest Michigan and get a link, or any of you can as well. We're waiting on a date to start training residents the same way.
And we can just join that. Do we need to register?
You have to register, so you'll get the real link.
Okay. Anything else before we move on?
This is Director Glenn. Can you, for purposes of just community edification too, just direct us where on this city website the notices are in the 5 languages designated by the...
They are not up yet. I was waiting on some support on how to make it user-friendly. Mm-hmm. And so if you notice, you don't know this yet, but we have a DEI page, a diversity, equity, inclusion page, and it has a link to the complaint. And so all of our information that is connected to Chapter 18, the Civil Rights Board for now, will be on that page. As soon as, and it's a recent page, so I'm still loading stuff on it. So hopefully I'll have that soon too.
Thank you.
Welcome.
Thank you. Anything else? Thank you, Vice Chair, for going through all that. We appreciate that. And we hope our citizens that listen or re-listen to this will get a better understanding of what we're trying to accomplish. So thank you for that. So we will move on to the next item of new business and discuss the Civil Rights Board name. I know there was some talk about this, and so this is open to anyone who has thrown out any ideas about a name change. So whomever would like to speak first. You don't have to rush at one time.
This is Director Harrington. I don't know what the name is and what the solution is. I do think it should be a little bit more encompassing of what it is we actually do. So I don't know if it's adding, I think I said this at the last meeting, adding community into the name, possibly, just to give some clarification around the confusion that we've had like the separation between the federal or the Michigan, you guys know what I'm trying to say, the Michigan laws and then what we do here locally. So just distinguishing between the two. And also connecting ourselves to the community as well, that we are here as partners and as advocates, and not as adversaries. So that's my contribution right now to the conversation, just to get us started.
So that's a good point. I'm wondering, to your second point, and this could be for Director Bonner, Vice Mayor, or Attorney Robinson, do we have the ability, and I know this is official, more official, but do we have the ability as a board to have a social media website, or does it have to be with the city of Kalamazoo? Like, can we manage that? I know we can share things, but is there someone that we could, could we do that, or no? Is that just at an official capacity because this is with the city of Kalamazoo? I've wondered that for a while.
It's the latter. We don't, what we want to have is a unified approach to all of our boards. So none of our boards have their own presence, if you will. Everything works through the city website. That way the city has some control over the messaging, and we get a uniform message that way.
Okay.
Sorry, the most you could do would be to have a web page. I know a couple of a committee has their own page within the city website, but they don't have their own social media presence.
And is that a request?
Well, for me, so
okay.
The challenge, I think, is going to be who is going to be responsible for feeding information to go on the site.
Yeah.
I mean,
I don't want to create more work.
I'm having problems feeding my own page.
Yeah.
So, who would take the ownership? You could share my page if that's for now, I'm offering that, but that would be the problem. What would you post, and who would keep the information uploaded, and providing information that we can give to the not IT staff, but the communication staff to keep, that whole process. It's doable. So that's something that you need to think through if you decide to do that.
Well, the goal, I don't want to create more work than you have right now, but
appreciate
just
that.
Ideas. But just ideas for the future as we establish this to, outside of this forum and, these meetings when we're updating the public. And I know that there's some things on the website, but just to be a little bit more active, really. That's what I'm thinking about.
This is Director Harrington. Director Houston, were you making a correlation between that and a name change? Is that why we were?
No. It was your last comment that you made.
Oh, about the community engagement.
Yeah.
Okay,
yeah.
Gotcha.
So this is Director Glenn. Tracking back to just the name change proposal, I understand that the Grand Rapids, and I think even Ann Arbor counterparts to this board are called the Human Rights Board, which I really like, and I understand is a little bit more of a global term, but I think it gets at some of those fundamental rights that we are trying to lift up that may not be embodied in state and federal law or provide a cause of action, right? Provide a remedy to people right now, but that we're recognizing these are fundamental rights of human beings, right? These are the fundamental rights that people should have to live a life of dignity and safety and access. And so I think that for that reason, and I know it doesn't have the term community that you liked, Director Harrington, but I almost think that it it's more encompassing of what folks experience, and then allows us to lift up at the municipal level. This is worthy of protection here. And so it would be my recommendation to follow suit with our sister cities, and to say, and because we borrowed so much of their language too, right? And they're a few years ahead of us. I would like to see us kind of move in that direction. And that would be my proposal.
And this is Director Brown and Director Glenn. I'm happy you mentioned that, because I was actually going to mention that after our last special meeting, I did a lot of digging and a lot of research, and definitely looked into, okay, since we had this learning experience, you know, again, I don't want to just learn and say, oh, okay, we know now, but how do we avoid that in the future? So definitely looking into some of the you know, around our local area. And then actually, I decided to even go even further out. And it looks like there's been quite a trend of name changing of these types of groups. And I wonder if it's because they may have also run into the confusion within the community of not really understanding fully. I mean, like I said, hey, I'm on the board and I didn't understand fully. So I just want to make sure that we are operating with absolute clarity and transparency and accountability. And I think, and I was actually going to suggest the same name, Director Glenn, of human rights, because I felt that it really did encompass those other areas where discrimination could occur. And you know, and it makes sense when we're talking about domestic abuse, or we're talking about, you know, convictions or anything like that. We know that there are definitely still some disparities in those areas. And so being able to cover that as well, alongside the federal and locally protected classes of, or state protected classes, excuse me, of the things that are written in the law. That's what I would agree. So I just wanted to just resonate that in my research, I realized the same thing, and then realized it wasn't just our area, it's even outside of those that are close to us that we've even borrowed from, that this seems to be the trend. So I just wanted to share that at the meeting, that Janine went and did some research and some learning. And I wanted to share that with the meeting. So thank you.
This is Director Harrington. Director Brown, are you saying that what you saw, it sounds like across the country, was it the name human rights, or were there other variations of that you saw?
I saw a lot of human rights. I saw something called just something like, they said something like locally or citywide. There were some different trends out there, but I did see kind of human rights pop up a little bit. So I think this is maybe it seems like a little bit more of a common nomenclature, if that makes sense. But I have seen what you've mentioned, you know, things that had community in the name. Housing, something was called, not housing, but like just exactly like what the area that they were, what do you call, the area that they were actually, you know, hearing investigations in. So, you know, just for an example, if it was housing or if it was education, and it was, when you read it, was the kind of the same stuff. You know, people being denied access to certain areas of the community that they should have rights to. And so, yeah, so there were some different variations, but I did see the human rights nomenclature come up a few more times. Now understand, I don't want to put the wrong idea out here. I didn't check the whole country now. I didn't do all that, but I did definitely check within Michigan and some of those other areas. And I think I actually looked into a couple of them in Indiana. And yeah, but I would see the human rights seem to be, at least in the Midwest. So before we get too glorified here, it does seem that that is kind of more of that, the nomenclature.
Thank you, Director Brown. One of the things that I think about here, and I will totally get to you, Vice Mayor. Vice Chair and Attorney Robinson. So the thing that pops off in my mind, if we change the name, when I think human rights, I think globally, and I see where we're going with that. But don't we want to define, because Director Brown said it, some places define themselves like educational rights or anti-discrimination or housing, obviously in the ordinance. Don't we want to be more defined so that individuals will know exactly what we do? Isn't the name kind of attached to purpose?
Can I respond to
I
that?
feel like when I think of human rights, there's a different thought process around human rights. I'm not banishing it. I don't say it's bad. That just is how my minds go. I think international when I hear human rights. That's just me. Go ahead, Vice Chair.
You reminded me of what I was going to say. First, I wanted to say that I agree with Director Harrington, Director Glenn, and Director Brown in saying that it could be more all-encompassing of a term, because I think what you're saying, Chair Houston, kind of like, of course, the definition is great, but our board does look at every aspect of discrimination. We just focus on those protected classes and other protected situations that we've defined within the ordinance. So we're still looking at every single aspect. And also in the ordinance, chapter 18, we are given a few sections that explicitly state that we can broaden this as far as we want. Like we could look back at other ordinances, or we could look at like other policies in the city or other laws in the past and review them if we really wanted to and we had the energy to make them less discriminatory or non-discriminatory. So I do think that like I'm if we're gonna change it from civil rights, I'm in full support of like broadening the term and not constricting it any further, because we do cover everything. Even though I think most of our conversations have been focused on housing, that's not the only thing that we look at.
This is Director Glenn. I would also just direct the board's attention to the New York City Commission on Human Rights that's been in place for several decades. And then the City of Cambridge's Human Rights Commission. So these are two very long-standing commissions in very large cities. The distinction in the New York City board is that they actually can levy fines and have an enforcement arm. But I think that's interesting. And, as we evolve, something to think about. But they have their own website as well, Chair. And so it is, I think, a very good example of what is possible in terms of the issue areas that are addressed by this commission. And then, but yes, they use the term Human Rights Commission.
Okay. Thank you. Attorney Robinson?
When I was drafting this, I took care because there was some suggestion or the idea that human rights might be appropriate, because you're right, I looked at Ann Arbor and Grand Rapids. And I came to the conclusion, based upon my legal research, that civil rights was a better approach. And I say this for this reason. Human rights is something that was recognized in post-World War II world with the Declaration of Human Rights by the United Nations. And it's like 30 sections long. So there is a document entitled Declaration of Human Rights at the United Nations level, and it's fairly broad. Whereas, and human rights is basically the rights you have in essence because you are a human being. Civil rights are things that are granted to you by the civil authority. And the reason why I felt it met our purposes better is that the city was recognizing other areas of discrimination that were not recognized at federal and state law. We were granting a civil right that did not otherwise exist at law. And so that was the reason I picked civil right, because that's what you're doing. It's a civil right that you're granting, as opposed to a human right that you have just by being a human and is recognized by the UN Charter, which again is it's not as simple as what we've pulled out a few areas of discrimination that we've had some documentation in regard to at the local level. It is a much broader statement in terms of what is a human right. And I don't think that we're at the Kalamazoo level, we're not prepared to go to that far yet. So that was some of the rationale behind the thinking that went into this drafting. It was not something that was not given some thought before I put pen to paper.
I have a question. What would be, sorry, I'm hearing my echo. Hopefully you can't hear it. What would be some repercussions if we were to change our name to the Human Rights Commission or the Human Rights Board? Like, what kind of things would we need to worry about if we broadened it to that?
I don't know that there's any worry to it. I just think that it's an imprecise term in terms of what is the expectation. Are we, if you will, would an individual think that we're really engrafting on the United Nations Declaration of Human Rights? I know other communities have done it. I'm not suggesting what they've done is wrong or it's the wrong approach. I'm just saying that when there is a legal difference between the term human right and the term civil right, and that's why our laws are, it's the Elliott-Larsen Civil Rights Act. It is the U.S. Civil Rights Act, because they are civil rights that are granted by a legal, statutory or governmental authority recognizing protection for these characteristics or these protected classes, as opposed to just being human. So I just throw that out for consideration.
This is Director Harrington. I'm wondering, can I give a suggestion for us to table this conversation for the next meeting and actually look at some other groups around the country that are doing the same thing that we're doing, and see what their purview of work is, what they do, and then have an informed discussion about it? Because I feel like we need to do thorough research about this, and what precedence has been set for other groups before I want this to be a thoughtful decision. And Director Glenn, just as you were talking just now, I went and pulled up those two communities, and there's a lot there, and I feel like as directors, all of us need to be seeing the same thing, and looking at the same information and comparing what those communities do with what we currently do and what we want to do. I also don't feel like we need to box ourselves into this now moment of 2021. We want to grow as a commission. We want to grow with the community, and really become a staple in the community and make a difference. And so I think we need to look at what's been done before us. I don't think it's wise to not take into account other groups that have been doing this for a really, really long time. Kalamazoo is new to this. Mm-hmm. Other communities are not new to this. So let's table this conversation and research. And, I'm more than willing to start the email chain with okay, here's a link to this community. Here's a link to this community, and have everybody look through that and read that. And then let's have this conversation at the next meeting.
I think that it should be shelved for a little bit of time rather than the next meeting. And here's my caution. My caution is that after an 18-month review of, some of the complaints that we get and oversee, and we're starting, I think that will help define and help maybe have a refocal point of our focus. I don't think that we're quite there yet. We haven't heard enough, done enough with the complaints that we have to make a name change. In my personal opinion, I would say maybe not. I think we should have some time before we think about a name change. I know where it comes from. I hear you. I'm not shutting it down. I'm suggesting we still have time before we make even changes to the bylaws that could come out of things that we've gotten from some of the complaints that we have to make a more informed decision. I don't think it's a next meeting type of conversation. I will not shut it down, but I'm just saying that I think it deserves more time as we go through this process as a board.
And I appreciate that, Director Houston. This is Janine again. Are any of us against just calling it? And I know that we're kind of going back, and I heard what Attorney Robinson said, and I thank him for that clarification and the why behind the civil rights name. But I'm wondering, is it a possibility that we could maybe just, because since we are formed because of an ordinance and the enforcement of that ordinance, can't that be in the name or just be the name itself? I'm just wondering, are we complicating something that could be very, very simple? Because we are, we're following a specific ordinance. We're not really reviewing the federal or state laws, in that regard. So, could that be a possibility maybe?
This is Director Harrington. I wanted to speak to that question, Director Brown, and also to Director Houston's comment. I think that we can set the tone for who we are and what we do. We have the authority to do that. I'm not really sure why we always feel like we need to tiptoe around stuff, around decision making, and act like we don't know anything and we don't have authority to do things. I would really like to strongly encourage us to divert away from that kind of thinking. What kind of difference are we really going to make in this community if we're always going, well, we don't know, and let's see. That's not activating speech, and we are an activating board. So I just really respectfully want to push back on that. Secondly, I think that we need to do our research. Now, is it something that may take a couple of months, to Director Houston's point? Maybe. I just threw out the next meeting just as a goalpost for us, because I also want to caution us to, not to table this conversation for like 4 months and then we never come back to it, right? Mm-hmm. So we need to set a goalpost of, let's revisit this in 2 months, or let's revisit this, whenever, but let's set a goal and a date for us to do our research and come back to this conversation educated and informed about what is going on around the country. And then Director Brown, to your point, I think it's important to do the research because, even at glancing at the Cambridge website, I think they also have 2 ordinances in place that are very similar to ours. So this is why I said, I think we need to do research before we say no or yes, or, let's read up on what some other folks are doing and have been doing for a very long time.
This is Director Beach.
Go ahead.
I just want to echo what Director Harrington is saying. And I also I think it's important to do the research too, because this is an ordinance. And when we're talking about a change, we're talking about it going through public comment again. And I think if we want to make sure we're doing that informed, we're making that informed decision, because this is not something that we want to come back to in a year and say, oh, this actually wasn't what we thought we wanted to be, and then change the name again. And then before we know, we've had 3 different versions of an ordinance just to change a name. So I echo Director Harrington's of tabling this. And I think maybe 1 month is a little too soon, but whether it be 2 or 3, we put it on the agenda and we start doing some intentional research and have an informed discussion. And because right now what it feels like is we're going back and forth over semantics with no what we feel is what we think. And so I don't want us spending time going over semantics, and let's maybe do some research. But I think so too.
So let me be clear, and I will get to Director Bonner. It is not diminishing our authority or even expanding an ordinances. What I'm thinking of in my mind, and correct me if I'm wrong, we're focusing on 18 and 18A. It's not like, to me, we're trying to figure out if we want to expand ordinances, and I'm saying that I don't think that we're there yet. If we're looking at doing a name change or looking at other names, that's what it sounds like to me. I could be wrong, but I'm not diminishing our authority. I'm not diminishing what we can do, what we're looking at in other cities. It's not that. It just, to me, when I look at it, our purpose is 18 and 18A. So with that, that's what I understand that we are enforcing.
Can I respond to that? This is Director Dela Cruz. Yes, we are focusing on 18 and 18A, but housed within those ordinances at the very beginning are explicit terms describing our roles, and those are pretty expansive. So I agree with Director Harrington. I don't think we should like shoot ourselves in the foot, or like stop ourselves just because like we're hesitating. I think like a lot of us have a pretty clear focus about like which direction we want to go. And in regards to that review at 18 months, I think, like, yes, of course, we're going to review like how we responded or how we dealt with all of the complaints, but that's not our only role. So like that review will encompass whatever we decide to do. So I don't think that needs to limit us. And I know you're saying that it's not going to, but I just want to like, I guess, reiterate what Director Harrington.
Yeah, I appreciate that. I appreciate that from all of you.
And
Director Bonner.
Go ahead, Director Glenn.
I was just going to say that I don't think that the name, the issue of a name is a fundamental question of this board's identity. And for that reason, I actually would like to make a motion. I mean, I perhaps don't need to make a motion, but I would recommend to the board, we do have this on the agenda for our next meeting, and we make this our work for the next month. That we all task ourselves with looking at what is out there. Because if you do look at these commissions, it is exactly who we are and what we are doing, but they are decades ahead of us. And so I think we need to get there. I also think it's going to help clarify a lot of the questions that are arising, the questions in good faith that are arising in the community about who we are and what our purview is. And if we are able to engage in that conversation now, I think we as a board are going to be clear on what our mandate is, where we can go, right? And aside from the complaints, some of the work that is possible here. And so I would just really strongly urge my fellow board members to get this on the agenda next month.
And so my comments are only about process. And Attorney Robertson, you can help me if I'm explaining this wrong. If we change the name, we have to change our ordinance, correct? And that would be 2 public readings and a public comment period. And so they just, Director Beach reminded me of that. When you said the public comment period, I wanted to make sure we understood an amount of time and that you are able to answer if challenged why. So just make sure if we were to do that, I would like in our presentation to change that documentation and that thought process. So we can answer it when we do it. That way we don't have to, I try to control as much as I can. We need to control narratives. We're not that great at it, but this is what I want us to do, okay? Anything to add to that process, Attorney Robertson?
No.
Okay. All right. That's all I have.
Director Glenn, I will be more than happy to add this to next month.
This is Director Harrington. Just as a final comment to that, thank you for that, Director Bonner. Because it is a big deal what we're talking about. And I just want to remind everyone that the reason why we're even having this conversation is because the community is confused about what we do. They're confused about what we do, and they're confused about who we are. So we need to be clear about who we are and what we do. And that may mean a name change, and that may mean a change to the ordinance to be more clear. So I just want to bring us all the way back to why this was even on the agenda to discuss.
Thank you, Director Harrington. So are we good to shelve this and move on? Attorney Rounds, I have to make sure, do we need to make a motion for that and vote? Or do we can just move on?
If you want to,
Is it required?
yeah, I don't know that it's required. Because as I understood it, and I guess perhaps it's best to vote on it, because I've heard there's discussion about doing it in 1 month. There's been a discussion maybe going 2 or 3 months. So there should be a motion and get a final decision as to how you're going to proceed.
1 month, 2 months, or 3 months?
So this is Director Glenn. I would like to make a motion to put the issue of name change on the agenda for next month.
A second.
All right. First by Director Glenn, and was that Vice Chair Dela Cruz that second?
It was
It was me, Director Brown, and I think Director Beach was seconding as well.
All right.
Right, Director Beach?
Beat me to it, but it's good.
Yeah, no, yeah, I saw us kind of open our mouths together. So
support.
yeah, I'm going to share. I'm going to share with Director Beach.
All right. So all in favor of moving the name change to the next meeting, say aye.
Aye.
Can I make a caveat? I'm sorry. I think it's important that we make the name change with the understanding of we're going to send out and do some research.
Yeah.
Come back with recommendations as board members, that we're going to come back with recommendations for name changes. I don't want to just push it back to the next meeting and then it be the same conversation. So I think it's important to put that clarification in that.
Oh yeah, I was going to. I
think
appreciate you.
this is Director Dela Cruz. I think we can just informally say that whoever comments can give like their reasoning behind it at the next meeting, and it'll be clear, I think, that if you've done your research or not.
Thank you very much. So the next topic we're going to move to is
I don't know if there's been a vote.
We didn't vote.
I thought we just did. All right.
The vote got interrupted by the comment by Director Beach.
All right. Screw up the flow.
Okay.
Which I have a question about that. So do we need to reword the motion then to add in what Director Beach just said for recording purposes?
No,
That was added in as a part of discussion.
no, that was just part of the discussion.
Right.
So it didn't
Okay.
change the motion.
Okay.
All right. I would like to ask for a motion to talk about the board name change.
Mr. Chair, you've already got a motion on the floor. All you need now is a vote.
All in favor, say aye.
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 Motion got first and second, motion accepted. All right. So we're gonna move on to discuss the chair and the vice chair reviewing complaints as they are received. I will say that this does not have to be exclusive to myself and the vice chair. We can open this up to another person. And I think what we are thinking about, and Director Bonner and Vice Chair, I know it was brought up in the special meeting to have, two of us be able to review. I know transparency is a big deal. And so what we were thinking about is meeting once a week or once every other week with Director Bonner and any complaints that we have, just to make sure that we stay abreast with what's going on. But again, this is not exclusive to myself or Vice Chair. I am more than willing to do it, but I wanted to give someone the opportunity if they would also like to be in that process. So to take on the leadership role for that. So this is up for discussion, anything that we think differently. And go ahead, Vice Chair.
I just wanted to add, this is my understanding of what it would look like. Feel free to interrupt me, Director Bonner, if it's incorrect. I think it would essentially be like a short meeting where we categorize, I guess, each complaint received, and it would be like broad to more specific. So then you'd check off like whether this is actually in our jurisdiction, I guess you could say, or if we're going to send it to a different agency. So it's pretty much like a checklist to make sure that so we're reviewing the complaints and then we're making sure that they would actually go to this process. So I don't think it would take that long, but it depends, I guess, on how many complaints we receive.
This is Director Beach. I personally think it makes a lot of sense for this to be a role of the chair and vice chair, especially on moving forward. So it's a clearly defined role that we know there's always representation. I think it makes a lot of sense, and I'm completely fine with it leaving at those roles.
This is Director Glenn. I would agree. And then I would also include language, and if we're going to really talk about amending the ordinance, maybe we could put this in, but that the chair and vice chair can designate a proxy in their absence should they be sick or otherwise unavailable.
No, I would like to make a motion that the chair and vice chair moving forward review all complaints that are received with the direct or a proxy review complaints with the director Bonner. Do I need to make a motion? I'm making the motion, being confident.
Own it. This is Director Harrington, and I second that motion.
Third.
Director Harrington, second, and Director Glenn, third. And all in favor, say aye.
Aye.
Any opposed? Motion accepted. All right. And the next order is to discuss a media point person.
My understanding about that agenda item is we were going to discuss the, and forgive me, Director Bonner, perhaps you can clarify the title of the new communications staff person for the city. But my understanding about this agenda item was whether they would be the spokesperson for this board.
Well, one of the things that came up, and I apologize because I should have had him here to speak for himself during that meeting, is that when the media comes to one of you all, we can't always say that y'all can speak. And so the question was, does everybody get to speak, or do you want to appoint a person to speak in case they're not satisfied with the public information officer and they want one of you all?
So, and that's why I wanted to clarify, this is Director Glenn again. I am opposed to the idea of the public information officer speaking on behalf of this board, because I think that we serve a very different role with regard to the city and representing the community. And back to that idea of transparency, really have very deep discomfort with the idea of having the city's public information officer speak for us. I'm not opposed to the board designating someone to speak for the board to make sure we're all on the same page, but with regard to the official public information officer, I am.
So, Director Glenn, I'm happy you mentioned that because I do agree. However, I would like to see about, even if we have a designee, it would be nice that there would be a process. So if we are contacted by the media, what's step one, what's step two, what's step three? And then whether we decide as a group that this is the narrative that we will be sharing, or if we, and again, that should be discussed openly, or if we should, have someone speak on our behalf, it still needs to be a representation. So making sure that we come together so that we have, like I said, I did try that, even though it didn't really turn out well. But it would be nice if we could kind of have a process for that. I like the process because I think the process is more of a representation, especially if we have questions or there are certain key points that we feel are most important as far as addressing concerns or the media or anything like that. So I fully agree with it not being the public officer or information officer as was deemed, but it would be nice if we could come up together with a process on how comments are made to the media or anyone on the outside and have that strategy in place. And then that be made well aware so then no one's confused and everyone's comfortable. So if you get contacted, I get contacted, Harrington gets contacted, we say, okay, we appreciate that. We have, and then it just keeps everything very transparent and open. And it is representative of what we want to say. And so I deem for more of a strategy. And maybe it's not just one person. Maybe it is whoever's willing to make that statement and take that out. I mean, we can do it that way. I think it would be good that people hear from the board as a whole, but just make sure we have a process in place that person's actually speaking on the behalf of the board. So if there's a strategy in place, I fully agree with that. And I like that. That's just my 2 cents.
No, it's a good 2 cents. I think it should be between myself and the vice chair, honestly, to be honest with you.
Well,
and I'm good with that too.
if I may interject, I think that this board does not have that power. You have a limited ability that's set forth in the ordinance. The city speaks with one voice. And in fact, under Michigan law, a public officer or public employee is not to represent his or her opinion as that of the agency that they are employed or serve. So while I understand that you feel that you've got some other special obligations, you are a appointed board of the city of Kalamazoo, and the city of Kalamazoo is attempting to speak with one voice through our public information officer. You as a group of individuals don't have that right to speak outside of on behalf of the city of Kalamazoo. That is a role for the city manager and for the elected officials, and that's where the buck stops, if you will.
May I ask
This is Director Glenn. Can I just follow up on that quickly? My understanding from what is being said is that we are not necessarily speaking for the board. We are speaking for ourselves. We are not speaking for the city of Kalamazoo. Right? We would be speaking for ourselves. But to Director Brown's point, I hear you, and I think having a process is very important to make sure that there is some support and understanding if you're looking to speak in your personal capacity.
I know that our personal PIO, what is it? Professional Information Officer.
Public Information Officer.
I don't know what, get the right P out, is working on a process for all of our boards. So it would be consistent across the board. I know what he said that night was if you can appoint somebody and that person would work with the Public Information Officer to make sure that the language crafted is consistent with what you all are trying to say and what the city's process. So this is another evolving thing. I see all of the faces. We're gonna figure this one out. But I know that night, that was his request. Could you appoint somebody?
So Director Bonner, so some clarification. The media, so what the request is appoint person to help work with the Public Information Officer to craft our statements on behalf of the city as a board.
Well, I've heard two things now. I've heard the conversation, I'm just gonna go back to where we started the other night, was to have somebody, if this is the way it works now, like if the media calls me, calls me to talk about anything with my position, I go through city manager's office and the public information office. That is our process. I don't go out and just start talking without everybody knowing. And the reason that that's important is you need the backing of this organization. When you go out there without them knowing, you don't really have the backing of them. Everybody needs to know what's going on. And so it just depends. And like I said, the PIO is developing the process. This is a new position that we haven't had a PIO in the 10 years I've been here. So all of this stuff is evolving. And the concern is the consistency of the messaging, even within you all, making sure that everybody in the organization knows that the request has been made and that somebody's going out to speak on behalf of the organization and how that works. So I agree with Director Brown that there has to be a process. So, we'll put it on our future meetings that we will come talk to you. We will bring the public information officer in. I'm going to request now that if you do get a request as the media, let me know so I can let leadership know, public information officer, so we can support you in who talks. We can have a process and a plan. Okay, that's just, I'm gonna leave it like that for now.
Vice Chair.
Hopefully this doesn't seem like I'm not a team player, but I'm learning that I have a lot of resistance to like making statements, public statements. And I'm wondering if like we did appoint a point person, if I was contacted by the media, would I just be able to just like outright reject it? Or would I still have to go through the point person? Or could I like bounce it off to somebody else? Just because personally, I feel like my personality doesn't mesh with that situation. And there are 7 of us. So I'm wondering, like, this might be a future conversation, but I'm wondering if I could like opt out of most of those. Or is that one of my responsibilities?
I'll be more than happy to do it with no problem.
This is Director Harrington. I'm sorry. I feel like we're talking in circles and I'm confused. So the original request and the reason why this was on the agenda is because our newly appointed, I guess it sounds like, public relations person requested that we give him or tell him who from the board should be, I guess, engaging with him to craft statements. Is that correct? Is that correct? Okay, so I guess that's why I'm a little bit confused about being admonished for us wanting to speak on our own, because I don't think that was the desire of anyone. We only have this on the agenda to converse about based on a suggestion from the public relations person. And so what we're trying to decide is who is going to be the person, or who are going to be the people that are going to work with that person who has been appointed by the city to craft these statements and to craft, I guess, responses. Am I understanding that correctly?
Yeah, I definitely think you're understanding it correctly. I guess the thing is that whether that process is for our chairperson to work with the public information officer, or one of us be appointed to work with that public information officer, no matter what it is, we need to kind of discuss what that process looks like. And I think that's what is why and maybe you feel like we're talking in circles. I think that there's I think really at the basics, really what needs to happen is we need a process. We need to know if we are contacted by anyone outside, or if there's any statement that is to be given on behalf of the Civil Rights Board, is what we call ourselves right now, then we need to know what's the next steps. I don't think.
For sure. And I agree with that. I absolutely agree with that. There does need to be the process. The original question on the table that was requested by the public relations person was, who is he supposed to talk to? And so what we said at the beginning of this whole convo is that it would be either Director Houston said, I will volunteer to do that, right? So I think we answered this question already a while ago. And we need to develop a process, correct?
Well, yes, and I see where you're coming from. I think the thing was that where the conversation started before our wonderful chair volunteered his services, which I appreciate that. I mean, 100%. I think that the question was kind of understanding and fielding what the public information officer was asking us. And then when Attorney Robinson responded, we just want to make sure that we're clarifying. We're not trying to talk about if it's on behalf of the city of Kalamazoo or anything like that, you know, publicly in that regard. No, we shouldn't be answering for that. That should definitely be the public information officer. So I think that where it kind of came back to was, yes, if there is if any of us are contacted, even if, you know, somehow we, you know, the process is we get in touch with Deshaun Houston now, Director Houston, and then Director Houston, you know, just know what that is. That's all we're saying, is just have that thing spelled out, understand what that is clearly. But the volunteerism kind of came a little bit after the original question. So I think, you know, if that's what caused the confusion, I definitely understand that. But I think that's what's happened here. So, you know, whatever you know, we decide to do, you know, I'm more than comfortable with going through our chair, Director.
Well, I think the other part of it is.
Yeah.
Thank you, Director Brown. I think the other part of it is that I thought that we had the authority to maybe appoint someone until Attorney Robinson told us that we really don't have that ability to do that.
Who are we appointing? I guess I'm confused. So we're saying who is going to be the person that's going to be speaking with the public relations officer, right? So how is that an appointment?
Yeah, I don't think we've had any vote. I think there's two different things that's happened here, Director Harrington. I think when the public information officer was on the call, he said he gave it as an option. You could either appoint someone that would with me, and then what we start talking about is, you know, how do we answer the media? So I think there was kind of two questions kind of thrown out.
Sure.
They've kind of meshed together into this, but I think what we recognize, just kind of at the basics, we need to understand how to move forward if we're connected by the media. I think that's number one. Whether it is someone we appoint as far as our board is concerned, or if it is Director Houston, then that's what we do. But I don't think there was any vote or decision that we.
Oh no, I know there wasn't a vote.
Just,
I'm not confused about that. What I'm confused about is that we said Director Houston volunteered, and then, you know, we were told we can't appoint someone. And that's where my confusion is.
Yeah.
So maybe Attorney Robinson can clarify, or Director Bonner.
Attorney Robinson, I think, was explicitly telling us that we can't shut out the city person from giving statements because we are a body of the city. I think that's what he was saying. So like we couldn't choose to give an interview instead of the city's person. And then the conversation about appointing a person, I think, was in reference to like who would talk to the city's public relations person. So I don't think it was like appointing a person to speak on behalf of the city. So I think it's just a lot of different things.
Can I make a recommendation for tonight? If any of you get a call from the media, let me know, and I'll get with your chair and a PI, public information officer, and we'll develop a response. Is that good for in the interim? Does that work for everybody in the interim?
Oh, I like that. That sounds good to me.
So just let me know, that way I could let all of the people who need to know that somebody is going to be making a statement. And then you all will all know what's happening. We'll make sure we send an email out after we decide how we're going to respond and what it is, because what we're learning in this season is that sometimes a written response is the best thing to do, and not even because, and this is, we all been doing it. I mean, we've been changing some of our methods because of the season we're in, and so is that works? I see everybody. Do I need to vote? Do y'all need to vote on that, or can we just roll? This is a temporary thing until we decide.
The process is created.
Okay. All right. Thank you. That's what we'll do. Thank you.
All right. We'll move on to the next topic, as to discuss and vote on our meeting frequency changes beginning in the next quarter. So as of right now, we will continue to meet once a month until the end of the second quarter. And then, but we can vote now to decide the frequency of how we want to move forward after that. So we can propose, I think, if I'm not mistaken, in the bylaws, it's, I believe, 5 meetings. I could be wrong. It's either 4 or 5 meetings, but I could be wrong in that. 4. So once a quarter. So we can continue to meet monthly until Q2 ends, but then going forward, what are we going to do for Q3? Are we going to continue to meet once a month or once a quarter at this particular point? And keep in mind, it's contingent upon complaints.
I motion, this is Director Beach, I motion that we continue meeting once a month. It's clear we haven't had a meeting go shorter, that we clearly have a lot to talk about and a lot to work through. And so I think there's a lot of work is just getting started. So I would motion, I want to make a motion that we continue to meet once a month.
We will until July. So we will until
Q3. I motion that in Q3 we continue with the monthly meeting schedule. That's my motion.
I second that motion.
Okay, Director Beach 1 and seconds that, and Director Brown seconds that. Okay, all in favor say aye.
Aye.
Any opposed?
Just a
All right,
comment. I should have said that at the other time. I'm sorry. You know that if your agenda is really light, like you don't have anything, you can also always cancel a meeting up to a couple of days before the meeting date if there's no agenda items. So just to have, so you have that option as well.
Thank you. And because you mentioned agenda, one of the other things that, and Vice Chair has done a fantastic job with this, is that we'll probably be submitting the agenda 2 or 3 weeks before. So it'll definitely let us know any changes. And Vice Chair, go right ahead.
Thanks for mentioning that. I wasn't sure if I should bring it up right now or miscellaneous comments. But normally the way that I make the agenda is just by looking at the notes from this meeting. So that's how I'll start it. And then I'll send it out to everybody, and that's when you can add stuff. I'm thinking the reason that we want to do this is, the reason we want to submit it and make it official earlier is so that we have time to get it ready or prepare it for anyone who might need some accommodation in order to know what's going to happen longer or like further ahead of time. We need more time to prepare. So just an FYI, I'm going to be sending out like a proposed agenda for like a first draft at the end of this week. And then I don't know what deadline we should have to have like it finalized to go through the preparation for the accommodations for disabled people. Like how far ahead of time do we need to have that?
I thought we talked about 2 weeks.
Okay.
Yeah.
All right.
You can translate it, so.
This is Director Glenn. Do we have any ability through, or are these meetings closed captioned?
Mm-hmm.
They are? Okay.
Mm-hmm. Facebook is closed caption. The YouTube, the replay is closed caption, or it's vice versa. One of the. Mm-hmm.
All right, so we're going to move on to 8, citizens' comments. IT, are there any? Yes.
I added an agenda item at the beginning of the meeting, an update from the education subcommittee. So,
sorry.
So Director Harrington, Director Bonner, Director Brown, if anyone wants to add anything, please do so. We have started meeting as a group. We were charged with coming up with a plan for some education around for the community, as well as for us as board members and landlords. So we met, we identified the kind of next steps, what we're going to be working on. So we will be hosting, we are coordinating with Pine Grove Housing, Chris Shepard at Pine Grove Housing, who is our MISHDA, who coordinates our MISHDA vouchers through the state of Michigan in Kalamazoo County, as well as myself. I am the program director at Housing Resources. So the city will be hosting a training for landlords in the first 2 weeks of May. It is the committee's request that we cancel our May meeting to allow for a landlord training to take place at 6 p.m. So that would also allow the board to go through the presentation as well. So that I would like to make that request of the board. And if anyone wants to add comments to why that request is made, feel free.
What's the date?
May 5th.
Okay. And that's
Is it May?
Wednesday.
Is it May 5th or May 7th?
May 5th.
Okay.
Making me second guess myself, Director Harrington.
That's my job. Sorry.
So I would like to make them, do we have to make a motion to cancel? Or is that?
Yes, under the Open Meetings Act, because you're amending your calendar of meetings, you have to make a motion and change the calendar.
So I would make a motion that we cancel the May 7th meeting of the Civil Rights Board in replacement of a landlord training on vouchers and rental assistance in Kalamazoo County.
I second that motion.
Motion accepted. All in favor?
Aye.
Director. Any opposed? Motion accepted.
The next things we're going to be working on are Chair Houston brought it up earlier. Director Harrington lifted up that the need for a centralized place for resources and training materials around the work we do and all around just the community member civil rights as a whole. So we are going to be looking actually at Director Bonner's wonderful DEI Office of DEI website and seeing where perhaps we could live on that site and where those resources can live, and having a really intentional conversation of what resources should be there, especially keeping in mind the maintenance of those and the frequency of those. So that's kind of on our next on our agenda for next meeting, as well as the education that was raised up by the rest of the board around real life examples around, now that we've reviewed the ordinances, some real examples of what this looks like in our community. And we are looking at the best way to educate the board and provide that support. So we met once, we are meeting again in a couple of weeks, really excited, and just want to provide a quick update.
So Director Beach, did you want me to still talk about the analysis to impediments?
Yes, I do. Thank you for reminding me.
And so for your education, and you were talking about real life examples, for the last couple of years, some of us have been working on a federal report called the Analysis to Impediments to Housing, to Fair Housing. And it is a mandated report by Housing and Urban Development that focus on, unlike their normal reports, is basically income. This one is based on race. And so that report is out for public comment. What I wanted to draw, and we wanted to share with you before I send it to you so you'll know what to look for. The first part of the report is numbers, data, but the latter part of the report is actually community voices, folks that were interviewed about their housing experiences. And so that will give you some of what you were looking for. Also, in that report is a report from the Fair Housing Center of Southwest Michigan, which talks about some testing they did with with banks and realtors about home ownership. And that will give you some more, if you know what a tester is, it's basically a seeker shopper. And so they sent out a Black one and a white one, and with the same information, they got different responses. So that's in there too. So I will send that to you. It is in in the final days of the 30-day public comment period, and after that, it will be sent to HUD. It is quite an amazing report. It also has in that report almost all of the work that we are aware of that's going on around housing in the city of Kalamazoo. All of the agencies, it's really a pretty phenomenal report as far as that report goes. And I say that because we work so hard on it. Thank you, Marissa, Jacob, anybody else who took that journey with us. So you'll get that, but that it gives us a start without having to schedule something. Some easy evening reading. Thank you.
Thank you, Director Bonner and Director Beach. Go for it, Director Beach. Were you going to say something?
I just remembered, Director Beach, I have a few names of advocates for the undocumented community. I'll send those over to you so you have them. And they're very excited and willing to do a lot of heavy lifting. So I'll send that to you this week.
Thank you. IT, are there any citizens' comments?
Before you do that, Mr. Chair, we just, Tanessa just brought up something to us that we put on the agenda to talk about the name change in May, and now we're not having a meeting in May. So thank you, Tanessa. So you all need to do whatever you need to do. I don't know if we can we just move it to June, or do we have to have another vote? I defer to Attorney.
I'm trying to recall what the motion was, whether it's to do it in a month or do it at the next meeting.
Next meeting.
I think we'll need
So
to.
the next meeting would be June. Okay, answered.
Yeah.
Everybody, we're good. Right? Is that right, Tanessa? She's not taking notes. We said next meeting, right?
Potato, potato.
Yeah, it was determined the next meeting, which was May, and we had said May a couple times. So I just wanted to make sure that we were clear since we canceled the May meeting.
Okay. Thank you for bringing that up. Okay. Excuse me for interrupting.
You're right. Thank you very much. Are there any citizens' comments?
Yes, we have one citizen comment.
My name is Richard Stewart. I am a resident of the city in the Southtown neighborhood. I'm calling with a few comments I'd like you to consider regarding the disability conversations. I feel Dorla Bonner was mischaracterizing the conversations she and I have had regarding the Diversity, Equity, and Inclusion Department not recognizing disability equal to race and gender. The entire conversation is around the exclusion of disability when speaking of the Diversity Department. It is not just race and gender. No DEI department that I know of does not include disability equal to race and gender. I believe that my request for disability inclusion and representation was mischaracterized in the way that it has never been about representation of a disabled person. Disability representation means a person in which people like me can go to that would understand our unique situation, our needs, or someone who even is aware of what ableism is. I don't believe many of you or staff members are familiar with that term or what it means or the diverse nature of persons with disabilities. Some are invisible, like mine, and some get worse over time, like mine. A representative is a person that people like me can go to with complaints or concerns. So it doesn't even need to be a person with a disability. That was a downright lie when Dorla Bonner told you that was never the intent or the request. The ADA is the only protection a person like me has from those bigoted persons who wish to take away the protections of equality guaranteed to persons with disabilities. The dismantling of the ADA to remove that equality is simply not acceptable. It is the only protections people like me have. And I am hoping that one of you on this board will consider how inflammatory the stand and assist with disability inclusion equal to race and gender. Thank you.
And that was the only public comment.
Tina Robinson, I asked for a little guidance. I mean, we did go over that in chapter 18 about disability as a protected class. You're on mute. You're on mute.
You have no obligation to respond to public comments. Public comment time is an opportunity for citizens to share their thoughts with the board, but you have no obligation to respond to those comments.
Okay. Any miscellaneous comments by any board members?
This is Director Beach. I just wanted to share with the community as a whole that this month in March, the Kalamazoo County received $17 million in COVID emergency rental assistance dollars that can assist people who are currently renting a unit in back utilities, back rental payments, and future rent and utility payments. So these funds are available now. So you can find all that information on Facebook. It's being shared on Facebook. There's a flyer. You can visit Housing Resources Inc. on Facebook or the website and learn about how to access those funds. But I just wanted to make sure the community knows that they are available and that there is help if anyone has been affected by COVID.
Thank you, Director Beach. Any other comments by our board members?
This is Director Glenn. I just, so I have two announcements. The first thing I want to say is that I feel such a great sense of privilege and responsibility being on this board. And I really appreciate how this board has, and specifically, really Director or Vice Chair De La Cruz, how you led us through that exercise, but how we are bucking convention in many ways. And to some that may seem as though this is an uneducated process, but I think there has been such a deliberative effort to be as thoughtful as possible about who we are and what this ordinance says and what it doesn't say and what it should in the future, right? But that although we don't have an obligation to, for example, respond to citizens' comments, that we can. And I've seen Director Brown do that. And I think the community is really hungry for that exchange and is excited about the possibility of having a transparent process to air discrimination and unfair treatment. And I hope that we continue down this path of being less concerned about Robert's Rules of Order and convention and saying the right thing, and more about making sure that we really get to the heart of what folks experience in this community and how we can do better. And so my second comment is that it's Sexual Assault Awareness Month in April. And among the Chapter 18 ordinances that we went over is discrimination based on that assault history. And it is all too common, right? That people have lasting mental and physical health effects because of their assaults. And it largely goes unaddressed. It's not just that initial assault, that it impacts your whole life and for some forever. And so just wanted to give a little shout out to all the survivors out there and say that I see you and you have really important rights. And there's an all-packed training on knowing your rights as a domestic violence and sexual assault survivor next week. And I'll make sure that gets posted to the city site. But thank you for the great privilege to serve with all of you. And that's it. Thanks.
Thank you, Director. Are there any other comments? All right, as chair, I'd like to adjourn the meeting. Hope that you all have a good evening and thank you so much for your time.
Good night.